Good day. This is an exclusive presentation for the subscribers to Estate Planning at the Movies, Art of the Estate Tax Return, the Author's Update Service. Welcome. I would like to talk about a case which came out toward the end of 2015 that I think is quite worth reading and is reflective of some excellent lawyering. The case is called Estate of Purdue, and it addresses three significant issues. First, whether a family limited liability company should be considered a retained interest for the interest gifted under Code Section 2036. Second, whether the interests gifted in the LLC are present interests as opposed to future interests under gift tax law. And third, whether interest paid to the LLC after death is deductible under Code Section 2053. I will say that in this case, the couple, Mr. and Mrs. Purdue, Mr. Purdue was a well-known attorney up in the Seattle area with a large firm there. One of his partners is Alan Montgomery, and Mr. Montgomery did the estate planning that led to the family limited liability company being formed. It's always a tense situation whenever you're doing estate planning to have your plan then reviewed by the tax court in a written opinion. Yet for Mr. Montgomery, everything worked out well. Let's look at the issues with the family limited liability company. The key assets were publicly traded securities. And normally, these take quite a bit of challenge in the tax court to have the bona fides accepted to avoid retained interest issues. The leading case was called Bondguard, and the Purdue case applies the Bondguard standard. What is significant is the planning that was done ahead of time to show changes of circumstances, different ways in which the investments were handled, the benefits of consolidating various holdings and coordinating the investment advice, in which the LLC was helpful to that end. This was recognized as significant in the bona fides of the consideration given and the respect, therefore, to avoid IRC Section 2036 retained interest treatment. Furthermore, there were substantial formalities followed after the entity was established, which further reinforced the bona fides of the LLC. In any event, the case is worth reading, and I suggest that you do so with Chapter 14 of your book, Art of the Estate Tax Return, handy. The book has a 29-point checklist of action steps to take, both before the LLC is formed, as well as after the LLC is formed and post-death, to help support the bona fides of the LLC interests that are being gifted and held in the estate. One matter in the case, by the way, was the children did not have separate counsel, and while that's normally a helpful factor, it was not determined to be adverse, or at least sufficiently so to change the outcome of the case. The children in this case were of a mature age, they were quite active, the terms were reasonable, so it was not fatal, the fact that the children did not have separate counsel. That was the first issue of the case. Second was the question of annual exclusion for the gift of the LLC interests. There are several decisions discussed in Chapter 6 of your book regarding the denial of annual exclusion treatment for gifts of entity interests. However, in the Purdue case, the record showed that the LLC paid distributions, number one, and second, it had a policy of making at least minimum distributions. That was a requirement, at least minimum distributions to cover the income taxes. So the court felt that this was a present interest. They looked at the LLC agreement and the activities of the entity, and so concluded favorably for the taxpayer. The third issue of the case was the deductibility of interest for funds borrowed from family members. Now, the issue in the case is, and this is a very important one, if the interest expense is not deductible on the estate tax return under Code Section 2053 as being reasonable and necessary, there is, by the way, no interest deduction allowed for income tax purposes. So it's a gamble. And counsel for the estate acknowledged that and told the clients. In this case, the borrowing from the family members was acceptable to the court. And the key fact, because the service argued that the LLC should have made a distribution sufficient to provide the funds rather than the estate going out to borrow the money, a key fact for the court was that the borrowing was reasonable and that it was not possible to borrow money from the LLC because any member of the LLC could veto the borrowing. And one of the members, in fact, disapproved the borrowing. Therefore, they could not borrow from the LLC. So therefore, borrowing from other family members was a reasonable action. So in essence, the case of the state of Purdue has three helpful results which are worth looking at, namely avoidance of 2036 treatment for the interest in the LLC that were gifted, as well as what's included in the estate. Second, the deduction of interest for purposes of estate tax. And third, the present interest treatment for the gifts in the LLC that were made over a number of years. So I hope that this is helpful for you, and do be aware on an ongoing basis with your clients that the IRS does continue to audit and to audit extensively family limited partnerships and LLCs for purposes of retained interest. In any event, a congratulations goes out to the Planning Council in the Purdue case. Thank you.